Put down the hammer, and pick up the pencil. You're about to listen to the Savvy Radio Show, yeah. Real estate info galore, so listen up, don't miss it. Hosted by the Savvy Landlord. Oh,
these two, these are both attorneys that I use on a regular basis. Robert Goldman has been an attorney for how long?
73.
Since I was born. Holy shit! So 43 years. He's been amazing. He has held my hand more times than enough. One time I got a call from Rob, I can't believe you did that. And he solved the case for me in the hallway multiple times. Anytime I have an eviction at all, I used to be dumb and stupid and do it by myself. I do no longer do that. For the last 5 years, I've used Robert Goldman. And then Jackie, or Jacqueline Short, is a general practitioner, real estate, whatever. She can do almost anything related to law, real estate. She has helped me with subject twos, any kind of unique situation. But they're passionate about real estate, and they're going to answer your questions. They got a little format, and so they're going to take over. Please welcome my two great friends, Robert Goldman and Jackie Short.
Before I launch into Landlord Tenant, I have this is a little course that's called Short Takes, and I'm going to give you guys a couple of nuggets. Because are you all landlords? Are you all looking to buy more properties?
yes.
Yes, good. Okay, number one. Does everyone know what a mechanics lien is? Is there anyone who does not know what a mechanics lien is? When you research a property to buy, and you see, for instance, if there's a mechanics lien for $20,000, what is the next thing you do? Very next thing you do.
Move on.
Who said that? I'm gonna throw something at you. No, you look to see the date of the mechanics lien. How long do they last in Oklahoma?
1 year.
2.
Wrong.
1 year.
Here, Teresa. Can you catch?
I'm out the way.
Okay. They last a year. Okay, somebody. Can they be renewed?
Yes.
No. So, voila, if you see a mechanics lien for $20,000, don't run. Say, hey, this thing is null and void. If it's been slightly over.
What happens when I've seen title companies don't close because that lien's on there, even though it's been backdated?
They might be ultra conservative, but what generally happens is it's not a problem, it's not a foul on title. But in the interim, while you're waiting to close, that person who put the lien on there could go to district court and file a regular action to try to collect. But that wouldn't affect you unless they put a list pendants in that gap. If they put a list pendants in the gap, that's why they do the gap search.
The gap between the
contract and the
rollover.
close.
Oh, contract and close?
Yeah, but otherwise, it's not going to affect you as a purchaser if they go to court and just try to collect it. But anyway, something to be aware of.
And what was the time? 1 year?
1 year, and they're not renewable. Second little nugget is foreclosures. I've been to the foreclosure auctions recently, and I noticed the people who, well, let me ask you a question. You're so smart at these things. Okay, the price that you bid and win the property, is that what you actually pay?
Probably not. I never bought one in the foreclosure.
Oh, you have not? Okay. Anybody? Is that the price you actually pay, what you win the bid at?
No, you pay 10% down there.
Well, yeah, but I mean, the total purchase price.
Yes.
The correct answer is it depends, because if you buy a property for $25,000, you are still going to be liable. The mortgages in a second usually go away. It's the tax liens, the mowing liens. There's could be IRS stuff on there. You might buy my friend, who's a seasoned investor, bought a property at the auction the other day and said it had $6,000 of liens that were put on it. It did not go away. So there's just the other nugget. Okay.
Quick question.
Mm-hmm.
If the IRS is named in the foreclosure action, does that wipe that?
No.
Okay.
No. They're omnipotent.
Jackie, shouldn't you just go to the courthouse and pull the file and read it?
You could, but there's 100+ properties
Well, I
auctioned
know,
off
but
every
I'm
other
not gonna
week.
bid on all 100, I'm looking at 20 or so. If I
See,
go
you'd
look
be
at
smart.
those.
You would know that before you went.
Yes,
But most
I
people
would.
just show up with their number and they just bid, and they don't know that they need to do
Another
some
one you
more.
might throw out there to people is that seconds are often bid in foreclosure and are not disclosed. There should be disclosed, but many times they are not
They should be.
disclosed. So you may be buying a second with a large underlying first.
Yeah, there's a lot of people who go to those auctions, they don't know what they're doing. I would suggest limit it to a handful that you are truly interested in, the location or whatever, and do your research on those. Don't go, I'm gonna, there's too many, you can't know everything
Haven't
about all
seen
of
them,
them.
don't bid on them.
Yep, so that's your nuggets. Okay, landlord tenant law. If you did show of hands, who owns a landlord? Just about everybody here. Do you think you know generally what you're doing in relation to the law governing you? How many of you have property management companies or manage property for other people? I do. Anybody else? Well, just be aware that some people, I've heard people say, I'm going to start a property management company. I'm really good at it. I've done so well on my own. And they don't realize that you have to have a supervising broker, and you have to be registered or licensed through the Oklahoma Real Estate Commission. Because you get in serious trouble if you try to manage and do stuff without the proper licensing, even though you might be great. The landlord tenant law is found at Title 41, Sections 1 through 36. Many have been repealed, or you can look it up on OSCN under the research tab, or you can buy this handy CD for $20 through the Savvy Landlord. Just pop it in, you can research and find all kinds of fun stuff. Are these statutes annotated?
What?
Are these just annotated?
I don't even
Does
know
it have
how
the
that works.
case law under the statutes?
It's on the back, it follows the CD. So which law goes with what track on there?
I would think these are probably, because it's not just the statutes.
It's
We
just
have
the
case
main-
law that construes the statutes and tries to clarify the statutes. Sometimes it makes it worse, but
Jack, you got a question, but when you say to manage properties, you have to be licensed under a broker. You're
Someone else
for other
managing
people.
somebody else.
For other people. You can always do your own. You can make your own mistakes. We learn the hard
You as an
way.
individual can hire someone to work under you, but you can't legally manage someone else's property.
There's a few exceptions, like if it's a relative, if it's, do you know what they are, the exceptions? Like if it's a property, if there's a apartment building, you can have somebody who's an employee of yours show the apartment. There's a few little exception things, but generally speaking, if you,
It boils down to the escrow money, and that's why that law was there.
it's because most people don't know the law. And supposedly brokers are more with it on knowing what the, discrimination laws and fair hat, all this stuff. They're supposed to, I don't know if they do or not. Okay, then there's been some, a little bit of a recent development in the law, and you may have heard of it recently. So let me ask Teresa. Can you legally refuse to rent to a person who otherwise qualifies, who has been arrested 3 times in the last 12 months?
No.
And why do you say no?
Because it's usually a good answer. No.
Arrested
I mean,
or convicted.
See, that is the
That's
difference.
a, yeah.
You cannot, supposedly under the new case law, it says you cannot discriminate simply based on an arrest record. It has to be an actual conviction. Misdemeanors, I don't know if they made it, do they make any distinction between misdemeanor and felony? For
I
that?
don't believe so. I'd rather tell them what I think.
No,
than what you say.
Okay, well, I just, as I understand it, the test is, there must be an actual conviction, and there must be a nexus between the conviction and the health, safety, or welfare of the tenant or the surrounding community. And then you have to consider how recent or remote the conviction was. And a new area, at least to me and some of my friends, is Airbnb. Does anybody have Airbnb in the room?
I used to.
You're still subject to the landlord tenant laws, but it's a little bit different. it's not, it's more the area discrimination. And I read an article that was put out by Airbnb that said they did a study and they found that the owners were discriminating against minorities. And they tested this by having guests apply for housing. And when they looked like a minority or they had a name like a minority, they were turned down a lot more often than when they had a name like, if they had a name like Tanisha and they looked like a minority, or if they had a name, they changed the picture slightly with the lighting and they put Donna, and they got accepted many more times. So anyway, if you do have an Airbnb, you still cannot discriminate in housing. I have an Airbnb, I have two, but they have a form in there that says you can refuse to rent to people with children, which I kind of have a problem with that. Next document.
You can refuse?
And under Airbnb, they will allow you to refuse to rent to people with children. I don't know how that would really fly.
But that's their internal rules, but it drops down to the state specific. I mean, the Landlord Tenant Act, I mean, you can still...
We might have a problem with doing
in a
that.
fuzzy area if somebody challenges it.
Here's an interesting lesson of the day. Do any of you know a famous landlord here named Ray Pelfrey? And I can talk about him because it's public record.
Yes.
You've heard?
Yeah.
Okay. He rented units. He has like hundreds of rental units in Oklahoma City, but he rented to young black girls. And then when he got them in place, he tried to extract sexual favors from them. And when they would not give in, he turned their utilities off. And the Attorney General issued a restraining order against him for doing that. So what is the lesson? What's the takeaway lesson? Don't rent to young attractive people.
Where do you start, man? Don't try
We have to
to
put
solicit.
this in writing so we get on your tenants.
Don't try to solicit.
Even if it's their idea, even if they're going along with it, I still think that would bite you in the butt later. They could say it's coerced or was rape. So that's just
Establish a personal relationship with your tenants, and don't pay for the utilities, and don't let them fix your houses. Okay, don't swap out that they're going to make some repairs on your house and they're going to waive the rent.
That's an excellent point.
Or give them a benefit on the rent. Don't ever do that.
I've never
Because you
seen
don't
that
know their
work.
workmanship, number one, and you don't know their price when you get in the court. It's always a problem.
Okay, I have a few little test questions for you guys. Can you make a handicap applicant show you how his animal helps him in a necessary life activity when he claims he has a service animal?
No, not necessarily.
Boy, y'all get some candy, everybody. Okay, somebody said catch. Catch. Because this is, you go. Ah! One. That was good. Can you demand proof that the service animal is on a national or state registry?
No.
No.
Well, look at you now.
Just had a long conversation with the legal aid attorney.
Can you legally refuse to rent to an applicant who has a 580 credit score?
Yes.
Probably.
Who says yes?
Yeah.
Who says no? Who says depends?
It's up to
Go backwards.
I think it depends if you have on your policy. You better have a consistent policy. You can't say this person can go in and this, but the next person must have it higher. So that would be mine.
Jackie?
Who said that?
What can you discriminate about service animals? Can you ask for their papers?
They don't have papers. They might have a doctor's letter, but they're not required The one thing you might be able to ask them is if this animal is truly a service animal, it must be trained to help them in a necessary life activity. The training is really essential. These two ladies tried to say their service animal was a hearing thing, and it had never had training, and it was a problem because it was not trained to actually help them.
So you can ask for proof of training?
I think you can.
Okay.
I ask a general, what about service animals or whatever? I say, please, just give me whatever documentation you have and are willing to give me, right?
That's
It could be
probably okay.
Yeah,
That's
well,
really, really touchy.
It is a touchy subject, according to legal.
But y'all know that you can't demand a deposit.
You can't ask about any HIPAA, what's your condition?
Right.
What is, you just ask for
Why, you
documentation.
can, there you go. In other words.
have a-
There's your lunch.
Will a pet fee apply then?
No.
Oh, no. You try that.
It's an extension of the
Here's the
person.
deal. Here we'll go to the next one. If you accept a pet deposit, what can you legally do with it?
I don't know, but I was thinking about a fee, not a deposit. Just a
Okay.
blanket fee for any pet.
If you call it a
Does
deposit,
matter
what can you legally do with a pet deposit?
Hold it in your deposit account and return it later.
Would you leave the room?
I'll give you one back.
If you call it a deposit, you have to go in your escrow account.
Sure.
But what can you do with the fee then?
Keep it. It's not responsible to keep it.
You don't-
Put in your operating account?
But so the question is, if they've got a service animal and you allow pets, you can charge a fee, right? Is it considered just a
No.
pet that you charge a fee against?
Not a service animal.
Service animal is not considered a pet, so they
Yeah.
can't have any fee or deposit concerning any service animal.
Yeah, the legal aid lady said it's an extension of the person and that not to be separated.
Gotcha.
There's another point. If they have what they call a service animal, and they've convinced you they've had a service animal, and yet the service animal is in the apartment barking all day, and they're out doing whatever, that's probably a sham thing, because if it's truly a service animal, it probably needs to be with them 24/7, because it helps them with necessary life activities.
I got one.
Seeing, hearing.
What if they
and-
have multiple service animals?
I don't know if that's ever come up.
Yeah. Couple of questions. One is, what if it's a pit bull, which isn't allowed
Okay.
under your insurance? Number
There is an exception that's being carved out for dangerous, and even though it might be a service animal, if it's a dangerous
Okay.
breed, you do not have to go along with it. And there's a sort of exception that if it won't potty in the correct places, if it won't do whatever, I mean, if it was a problem, you were probably okay in tell them they can't have it. But
No,
I
what
wouldn't
about-
want to go there.
Now, what if they had more than one, or what if they said it wasn't to help them, but just to comfort them?
Emotional animals are different than service animals.
Okay.
What about an assistance
Can
animal?
you ask for that difference? Because I've had that happen, so.
When they apply for the housing, they're supposed to tell you then, if it's applicable then, they really need to disclose that then, so that you will know to make a judgment call on it.
What if they get it later?
Well, they might have an accident and have a disability that they need a service animal.
Okay.
So what's the difference between emotional support and a service animal?
I think it's the federal law that governs. There's the ADA, and then there's HUD, and there's the Americans with Disabilities. There's all these
So as a
laws. Some of them
landlord, I
don't.
mean, you charge
One
pet
of them
fees for
applies for
emotional
housing, and
support?
one of them is like transportation and going in restaurants. You can take your therapy dog in a restaurant or on a bus or a plane.
But as far as where we treat them as a
They get a
pet,
fee then.
they're the same.
Emotional
I think
therapy,
emotional
support.
support is, we can't.
I've got one that's got PTSD and so he's got a dog. Seriously,
Are you the emotional support for the animal?
yeah.
So you
Okay,
can't charge a fee
Robert.
for emotional support, or you
Robert's
can't?
going to come and join me because I have a couple of questions before we open it, because I know you guys have tons of questions. He's Mr. Evictions, Mr. Landlord guy.
All right, let me clarify a couple of things, okay? For years, the apartment industry had security guards on their property. And tenants would then feel like they have security on the property itself, which caused a lot of problems and a lot of lawsuits. And to get around that, a lot of the management companies changed their nomenclature and called them courtesy officers. And let me just put it this way. If it looks like a duck and quacks like a duck, it's a duck. It doesn't matter what you call it. It doesn't matter if you call it a security deposit or a fee. It's still going to be regarded as a deposit. So there's no way that I'm going to tell you to try to be cute in any way in order to try to get around what the state of the law is, okay? I'm Robert Goldman. I'm an attorney. I've been practicing landlord tenant since 1977. I'm very active in the apartment association. I'm the legal counsel. I'm a past president of the Oklahoma Multi-Family Housing Association, which is a state agency. I go occasionally to Washington, D.C. for the National Apartment Association. My father has had property in New Jersey. Let me just tell you that we have probably the most lenient landlord-tenant laws of any state. I mean, we actually have a state that gives tenants responsibility for their actions. And the biggest responsibility for you, besides providing the house, is to make sure that it's habitable. That's the issue. If you're in it just to make money and not put money back into the house, and you're going to go to court on any of these eviction cases, that's where you're going to run afoul. If it's not habitable, if it's not in a state where you would be willing to live there, believe me, they're going to find a way to help the tenant in the issues of an eviction case. Irregardless of the fact that Judge Croy will get up there and speak for 20 minutes on the rights of everybody and say, don't tell me that it's a rat trap with cockroaches and you still want to live there. He makes it sound in his preamble that if they don't pay the rent, they're out. But that's not the case. If that case goes to trial, he's going to find out what a rat trap, cockroach infested place it is, and he's going to turn that around on you and say to you, what would you pay in order to live in a house like that? And believe me, he already knows the answer to that. So if he leans back in his chair and he's asking you questions, it's not because he doesn't know the answer to the question. It's because he's now formulated his decision on the case, and he's going to put you on the spot to make sure that you understand that he won't tolerate that type of activity. All right, landlord tenant, let's talk about that. Let's talk about, first of all, what you need to do to protect yourself when you're going to court or when you're renting a property. We are an industry of forms. It's unfortunate, but that's true. And it's important that you have a good application. You do good background checks. You find out whether there are evictions. In the past, on criminal activity, I would always ask or suggest on an application about felonies that they have committed and any pending charges, because I always felt that it's no good for my landlord to put somebody into a unit that says they have no felonies when there's a pending charge, and in 2 or 3 weeks they could be entering a plea on a sexual predator type of case. So we always threw in there pending charges too. Well, the change has taken place through HUD, actually. It's not a state statute, it's not a federal statute. It's more of a discrimination situation, because 1 in every 3 male adults in this country have a criminal record. Where they got the statistics from, I don't know. And there is a disproportionate amount of black and Hispanics and minorities of all kinds that have a higher degree of criminal convictions than the white race. So they found now that that's a disparate situation on minorities. And if you're going to use criminal activity as a means of keeping people from renting your properties, you're going to have to tell why. You're going to have to do it on a case-by-case basis. And of course, if it's a criminal case that's involving the manufacture and sale of drugs, you're going to have a stronger case of saying why you are going to prevent that person from living on your property. If it's a DUI that happened 10 years ago, you're not going to have a strong case. It's going to be on a case-by-case basis, and you can't ask me, well, what about this situation? Or what about that situation? Again, they have carte blanche on going ahead and examining these cases based on the directive that came out of HUD, that it's a case-by-case basis, and if we feel that you're discriminating, we're going to go after you. And let me just back up a little bit too, and I'll tell you that everybody that's in this office, everybody that has management, that has other employees, should recognize that every potential contact is a fair housing violation. They have shoppers out here that will shop you to determine whether or not you are following the law. How do I know that? Well, I am also on the Metro Fair Housing Board, okay? One of the reasons I went on the Metro Fair Housing Board was because I wanted to see how they do their business. They are funded on the number of complaints that they handle. It doesn't take rocket scientists to realize that they're going to investigate cases, some which, when I was not on the board, I felt for sure was more of a civil issue than a discrimination issue. On deposits, on things like that, not getting the money back, not doing repairs. So you've got to be very careful, and it goes all the way up and down the line, from you to all your employees to your service techs. Anybody that's involved with your business could potentially create a fair housing violation that will go all the way up and down the line. There's no protection except for making sure everybody is aware of fair housing and that they treat everybody equally. You know, it's like kindergarten. You learn that you're supposed to treat everybody equally. We all have built-in prejudices and biases, but it does not come into play in the housing industry, and it shouldn't. That agency that I'm involved in, you wouldn't believe some of the complaints that we hear, and it's just fundamental. I think people do things that they certainly shouldn't be doing. But you need to have a good application. You need to have a good move-in sheet right from the start, where it's checked off by both you and the tenant, and at the inception of the lease, you should have pictures of your unit. This is all in contemplation of the fact that you may be going after them for damages at the end term of the lease. So paperwork, paper trail, preparation, that all comes into play as far as whether or not there's damage. If it's a situation where you don't have that information and it's the end of the lease and there's a spot on the carpet, you say that you did that and the tenant says it was there at the time, you're going to lose that type of case. If you have pictures, if you have the move-in, move-out sheet signed by the tenant, you're going to win the case. It's just that simple. And then you got to consider depreciation of the carpet too. You're not going to get 100 cents on a dollar for a replacement of a carpet that's anywhere between 7 to 10 years old. It's got a life of about 7 to 10 years. So on the application, the other thing is this. You should have anybody that's going to reside in your property that's over the age of 18 to fill out an application. It's a red flag to me if there's a husband and wife, and the wife's going to be on the lease and sign the lease, and the husband's going to be just an occupant and not going to submit an application. That tells me right away that there's something going on. So anybody over the age of 18 should be filling out the lease. You don't want somebody to go ahead and enter into a lease agreement for the purpose of giving someone who would not be eligible to get into your unit, and maybe that other person won't be in there, the person that signed the application. So you got to do a thorough job. You got to do a thorough job. As far as the evictions go, there's 4 notices in the state of Oklahoma. And I will tell you from the outset that there's no self-help in the state of Oklahoma. No self-help. No shutting off utilities, taking doors off, not making repairs that need to be done. Things of that nature are going to get you in trouble. So in order for you to do a legal eviction, you've got to go through court. Now, on abandonment of the tenant, it's a very subjective test. You're going to have to decide whether they've abandoned the unit. You can't call an attorney up and say, hey, I think they're out. That's going to go back on you. So how do you determine that? Well, you determine it by whether or not the utilities are on. You determine it by whether or not there's property within the unit still. And you want to make sure that you are erring always on the side of being conservative. My phrase to my clients is that I always want you to be the hunter and not the hunted, okay? Because you have something they usually do not. They have nothing to lose. And that gets into their personal property. I've never seen a landlord get rich on holding a tenant's personal property. It's such a hassle, and it's junk to you, and it's priceless to them. And not only that, in that chest of drawers, there's diamonds in there or something of that nature. So get them back their property. If they want their property, don't ransom their property, because it's going to be just something that you're going to hold on to for a period of time. There's a list of items that are completely exempt from you holding on to them. It just doesn't work very well. It doesn't work very well. Okay, let's talk about the eviction process. Again, there's 4 notices. Notices are jurisdictional. You don't give a notice, you're not going to win the case. It's just that simple. It's going to be the first thing that any of the judges are going to ask you. In Oklahoma County now, there's 4 judges that handle this on a rotating basis. They're not doing it on a pure rotation now because they're short some special judges. So they've taken Judge Walkie away from the eviction court. He's doing mental health and drug court right now. So right now you're down to Croy, McElwee, and Easter. Each one of those are different. They all interpret the law different. They all handle their courtroom different. Some of them are very strict constructionists. Some are very loose constructionists. 2 out of the 3 are more strict, and 1 is pretty loose. So you want to prepare yourself for the strictest judge so that you're prepared for all the judges. And again, they do it for a month at a period of time. I found the same thing down in Cleveland County. It's a little bit more lenient down in Cleveland County. Same thing in Canadian County. We go to Canadian County, and we even go to Potawatomi County. So the notices. You're going to be stuck with what you put into your lease agreement, where it is to your disadvantage, not to your advantage, okay? What I mean by that is this. Some of you put in there that you'll give them a 3-day notice instead of a 5-day notice. That's not going to fly. The statute says 5 days. That's what they're entitled to. You can't do less than the statute. If you get too cute and creative and say that you're going to give them 30 days to pay or 15 days, you're going to be stuck with that because you've created the ambiguity. Anything that you put in there that's ambiguous with the law is going to be decided against you. So 5 days is the proper notice to give on non-payment of rent. Late fees. I have a very personal interest in the late fee issue because I actually was the attorney that lost the per diem late fee case that went to the Supreme Court. okay? I don't win all my cases. You know, when I come here, I always feel like I'm at the zoo and there's seals out there because everybody's throwing candy all the time. In that case, I actually won it before the trial court, and I won it before the Court of Appeals, and then they took it up to the Supreme Court, and the Supreme Court went from point A to point C, and they already had decided they're not going to allow per diem late fees. And what I mean is the $5 or $10 per day. So you don't want to have that, okay, in your lease. And certainly the judges are going to be more strict on you on everything else that goes on if they see that in your lease. They may even ask you, how long have you been receiving this per diem late fee? And if the tenant is now late, they may apply what you've illegally been taking as a per diem late fee and apply it to the rent. So you need to be with it as far as what the changes are, what the attitudes are, and what the law is in order to you to be successful. The 5-day, if you, they used to have the 5-day notice at the clerk's office. Don't try to embellish that 5-day notice. Make sure you have a good 5-day notice. Don't put things in there that would be confusing. You want to give them a 5-day notice. Rent is usually due, and it should always be due in your leases on the first day of the month. If you read your leases, the late fee should kick in about the 3rd, 4th, or 5th. Now that doesn't mean the rent that the tenant has the ability to pay the rent on the 5th without being delinquent. Technically, if it's due on the 1st and it's not paid on the 1st, they are late at that time. Again, it depends on language in your lease. So, technically, you can give them a 5-day notice on the 2nd if it's due on the 1st, irrespective of when the late fee is supposed to kick in. You can't ask for a late fee at that time because it's not late, it's not the 5th at the time. But if they owe you $500, you can give them a late 5-day notice by the 2nd of the month. That starts things rolling, okay? The tenant has the absolute right to pay you. These statutes are what is called curative these notices, they're curative, meaning even though the lease sets out specific things that the tenant's supposed to do and you're supposed to do, the legislatures come up with these fictions of saying, okay, even though you're late, you're going to have to give them a notice to quit in order for them to be in default and for you to pursue your case. So that's what the 5-day does. And aside from the 30-day that I'll talk to you about in a second, the 5-day is the easiest way to get them out. That's simple. Which means that if you give them a 5-day and you have an office and a manager, you should tell them exactly what's going on. So you're all on the same page. So when a 5-day is given to them, you're under no compulsion to accept the partial payment. You accept the partial payment, then your 5-day notice is no good anymore. Because now the court looks at that like you've entered into a new agreement with the tenant. So I'm not telling you in all instances to not accept the rent within the 5 days. If they owe you a considerable amount of rent, and I don't know your status as far as cash flow, they say I'm paying you this X amount of dollars today, and I'll pay the balance by Friday, and you want to go along with that, that's fine. But you turn around and give them another 5-day for the balance that they owe. In more instances than not, you're better off not to accept a partial payment. Yes?
What if you have it set so it goes to through Buildium? And what if you have it set so it goes through Buildium? So it's automatically accepted by your software?
Well, I think you need to write them and let them know that you're not going to accept a partial payment, whether it's to you directly or through electronic
You
payment.
can turn it off
You
on
can turn it
building.
off.
You can turn that off.
And you might even want to put that into your lease agreement, that in the event that they are delinquent on your rent and a 5-day notice is given, you're not going to accept a partial payment, whether it's directly to you or through electronic payment. Yes.
If you, let's say you're on day 3 of the 5-day notice and you take a partial payment and give them a new 5 days, at the end of that 5 days, that then will be the end of this or no?
Yes, provided that they don't pay you. They say they're going to pay you. Yes, Al?
Say, for instance, the 5 days is up and you filed for the eviction, and then they come to you with the money and you say, well, now you owe me for some filing fees. Section 8 doesn't like that concept, because they say the filing fees go to whoever wins the case. Well, I'm trying to keep it from going to court so that there won't be a case and they will lose their housing. So how would that work? How would you word that?
Once that 5-day notice lapses without the payment, you're in complete control, because technically the lease has been terminated on that 5-day notice. Now, residential is different than commercial. You can't accelerate. You're not going to go after them for future rents. The 5-day notice pretty much tells them, pay the rent in 5 days or I'm terminating your lease. And if they don't pay within that 5-day and you've gone ahead and you've filed against them, you're entitled to be whole. You're not required to eat your costs or your attorney fees to let them stay in after that 5-day period, irregardless of what Section 8 says or OFA says. You're now in control of the deal. Anybody have a question on that? Okay.
Can you go over the timing on the 5-day notice? Like if you post on 4 o'clock on a Monday?
I'll do that right now.
Okay.
On the 5-day, there's 3 ways to serve each and every notice. You have to do it one of the 3 ways. You can give it to them in person. You can give it to someone over the age of 12 that resides in the house, which is just astounding because, you know, when I had young kids at 12 years old, I just can't imagine that they would do the right thing and let me know I've been served, something like that. But even at 20, maybe 30, who knows? But anyway, so, or if you can't serve them in person, or a substitute service in the house with somebody that resides there over the age of 12, you're allowed to give a notice by posting on the door and sending certified mail. They're not required to get the certified letter, but you're going to be required to bring to court the receipt that you sent it certified mail. Some judges will allow you to continue your case by doing the certified mail at the date of court. Judge Croy will say you don't have service and you got to start over. Yes.
For giving the notice, does that have to be in order? So like person, you couldn't do it, over age of 12 couldn't do it, and certified mail? Or does it matter?
Well, it matters to this extent. The last type of service, the posting and the certifying, is a constructive service on the tenant. And you're supposed to use due diligence in getting the tenant served. So they're saying, okay, you're going to try to give it to him in person, he's not there, or someone over the age of 12, they're not there, then I can post and certify, which makes an important point. You don't want to send certified and then post, because then you're defeating the whole due diligence of trying to get them served. So if you go there and you post it, let's say you post it today, and you got to send the certified tomorrow, it's 5 days from the last item, which is the sending of the certified.
I've heard two different things on that. I think we've even spoken about it here, potentially, can you not just send certified? You literally have to approach from the door in person?
There's 3 ways that are put in the statute about serving it. It's either in person to somebody over the age of 12 that resides there, or posting and certifying. Those are the 3 ways.
Together, posting and certifying? Okay.
If you send it certified only, let's say you send it certified only, the only way that I think you could make an argument to the court is if they sign it and you get the card back. Otherwise, you haven't done anything because we're talking about due process. What's due process? It's the process that's due to get them into court or due for them to do an act that's required of them under law. And if you send them certified mail and they don't pick it up, then you haven't done proper service without posting and certifying.
Yes, sir. How do you prove that you posted?
You get up there and you raise your right. You can take a picture. More people are taking pictures than usual, but you just have to say that you did it. And on the bottom of my 5-day notices, there is the 3 ways to go ahead and have them served. One says, I served the process by handing it to Joe Blow on this day. The second one is I served this by serving Jimmy Blow, who is his son over the age of 12. And the last is I served it by posting a copy and sending it certified mail. You must bring the receipt to court. Must. The receipt, again, is not the green card signed. It's just the proof that you went ahead and you served it. And again, well, let me get back to one more thing. Just for your knowledge, the judges regard $50 as an appropriate late fee. $50. Croy was stuck on $25 for years, and this last year he came across and he's doing $50. For the first few years, Easter wouldn't even give you a late fee. So whether he gives you one or not, it depends on the day that he wakes up and what side of the bed he's on. So that's just a point to know. The second type of notice is for a material breach of the lease. And what we're talking about there are those cases where they have an unauthorized pet, unauthorized occupants, they're parking on the grass, they're not mowing the grass. That's part of your contract. Trash, things of that, or where they're in a multi-unit situation interfering with the quiet enjoyment of the other residents. That's most of those type of complaints. And it says this: you're breaching the lease or you're violating the statute by having an unauthorized occupant. You have 10 days to rectify this breach, or on the 15th day, I'm going to go ahead and terminate your contract. So it's a time frame of 15 days, giving them 10 days to rectify it, or on the 15th day, you're going to go ahead and terminate the contract. Now, again, when you go to court, you're going to have credible proof of what's going on, either pictures or some information to show the court why you feel that they are in breach of the lease. They have an absolute right, again, because it's curative, to resolve that breach, to get rid of the dog, or get rid of the unauthorized occupant. And what we did under this statute was we made it where if there's a subsequent violation of the similar type of breach, it will be grounds for you to terminate the lease. So at one time, we were worried because they'd be interfering with the other neighbors, and you give them that notice, and on the 9th day, all of a sudden, they were okay. And then the next day, next month, the same thing. They would just go right up to the edge, and then they would resolve the issues. And we said, that doesn't make sense. Why should we keep giving them ad infinitum these notices when they are just playing the system? So the statute changed, and it says, if there's a subsequent violation of the similar type of complaint, it's grounds to terminate the lease. Now, let me just tell you that I don't like my clients to be pen pals with their tenants. All these notices that we're talking about, they have a meaning and a purpose, and you could tell them, behave yourself a half a dozen times, but until you give them the appropriate notice, you haven't given the judge proper jurisdiction to hear the case. And if they violate that same 10/15 the next month, what I tell my clients to do is say, we gave you this notice for unauthorized occupant in February. Here's a copy of it. Now we're into March and you have the same problem. We're terminating your lease, be out in 48 hours. And then go to court. But have your competent evidence that you have proof that they're in violation. Yes.
Do you have to give any other type of notification? Like you said, they have to be out in 48 hours. You have to post a 48-hour notice to vacate?
I just think that's cleaner. There's no provision in the statute that requires you to give them another notice.
Okay.
But what I think is this: it's not such a cold case where you just go ahead and you file on them immediately, and they say, "Hey, I don't even know why." Here, you're showing the court that they were not in compliance the last month, and then they corrected it, and now they're not in compliance this month, and I'm availing myself of my rights under the statute to go ahead and terminate their lease.
Can you do that from mowing the lawn, from them not mowing the lawn?
But,
Is that just one of
well, that's one of them, but you can't use unauthorized occupants in February and then not mowing the lawn in March. Those are separate. They have to be the same nature of the prior breach in order for you to be able to terminate the lease. Yes.
So you're saying if, let's say that unauthorized occupant is twice, and you can give them a 48-hour notice and then they have to vacate? What if they don't? What if they choose not to?
Well, again, what I said in the beginning is there's no self-help in the state of Oklahoma. This is all questions of proof. This is all evictions. You're going to have to file your evictions. Yeah.
Does that apply?
This gives you the opportunity to have your day in court based on their breach of the lease.
Does this apply to just paying late every month? Not paying unless you post?
No, because that's on you. When you say paying late, what does that mean to you? Does that mean that they're paying?
They basically won't pay unless you post. If you post on the 2nd, you'll get it on the 7th or 8th. If you post on the 10th, you'll get it on the...
That's a little game they'll play, and you're going to have to go with that. Now, if they ever miss that payment, then they're out. So, yes.
So after posting the notice for the dangerous animal, before vacate, and if the animals hurt anybody, will that waive the landlord from liability?
I don't want to make a snap answer to your question, okay? There's a lot that could possibly happen. If they have an unauthorized pet and you're going through the process of getting them off the property, then I think you're doing what's appropriate, because that's all you can do under the law in order to get that pet off there. If they have a pet,
right?
I'm sorry?
It's a 10-day notice?
No, there's not. Well, it depends. It depends. If they have an unauthorized pet that has gone after somebody, I give them a 48-hour notice, and I'll get into that in a second. Okay, but if they have a pet that's just there, then you might have to give them a 10-15.
And you used the term self-help a couple of times. Can you explain that?
Yeah, you can't take the door off, you can't shut their utilities off, you can't take their personal property and put it to the curb. You have to go through the courts in order to get them out. That's what I mean by self-help. And I'll give you the example what happened, and it was a commercial. It was a Mexican restaurant. They were negotiating for a new contract. They were already under contract, and they couldn't come to the terms of a new contract. And the landlord went over there at midnight and took all their belongings out and put it in the street. And the court said, you can't do that. And their argument was that it wasn't a breach of the peace because they weren't there. But the language went, if the tenant wouldn't want that to happen, then that's a breach of the peace, even if the tenant wasn't there. So they paid a lot of money for closing that guy's restaurant by not going through the court system to do that. And they applied that commercial setting to residential too. Yes.
If you have a 1-year lease with a tenant, and there's been a couple of problems over that year, and can you at the end of that 1-year lease say, I don't want to rent to you again?
Absolutely.
30-day notice?
Absolutely. And that would get into the fourth notice. But let's get into the third one real quick. And I'm keeping you here longer than you probably want. But anyway, if there is a material breach of a lease that causes or threatens to cause imminent harm and danger to the property, to other residents, or the management personnel, you can terminate that on a 48-hour notice. So what are we talking about? We're talking about criminal activity. We're talking about drugs. We're talking about threats made to you of bodily harm, or threats made to you, to your vendors that are going over there to do work. And look, there's no doubt in my mind that every maintenance crew person knows what marijuana smells like, and I doubt very seriously if there's anybody in here that doesn't know what marijuana smells like, including myself. But that was a long time ago.
Now we're talking about marijuana.
You gotta go?
No, it's 1 o'clock. You can leave if you want to. We can do a quick round of questions. First of all, put your hands together for Goldman. The normal question I get a lot is, how much does it cost for the process? Did we already cover that? Cost? Okay. What does it cost to evict somebody?
It depends.
How much is the filing fee?
The filing fee is $58 if it's under $1,500.
Okay.
And then you have the processor fees, and then you have, if you have to use the sheriff for the lockout, it's going to cost you just under $117.
Okay. And then what's your fee?
It depends.
You went up in value. I definitely.
The last two notices real quick, okay? That 48-hour notice is what we would give on a criminal activity or something that's causing or threatening to cause imminent harm and danger, property or other residents. And again, proof. You're going to have somebody there that's going to have to testify. You can't do it by affidavit. That's hearsay. They have to be present in court in order for you to win your case. They have to be there so they can be cross-examined. And I'm just going to go through the last notice, which is a 30-day notice. And here's the deal on a 30-day notice. The lease is either at the termination point or they're on a month-to-month, either one. Again, I'm assuming that rent's due on the 1st. You must give that notice from rent-paying period to rent-paying period. And what does that mean? You got to give them a notice. I tell my people to give it to them on the 25th day of the month to end the last day of the next month. That sure gets you through February. That who knows how many days are in February, but it just keeps changing. So you've got 30 days, but you're supposed to give it from rent-paying period to rent-paying period, and they're supposed to give it to you from rent-paying period to rent-paying period. If they're a problem tenant, they're going to give you a notice on the 5th to be out the 5th of next month. Fine, just let them pay the prorate if you want to get rid of them. If they are not a problem tenant, you could say, look, I'm sorry you're giving it to me on the 5th of March, but that means that the lease terminates on the 30th of April, not the 5th of April. And there's case law to support that.
Does that hold up? Do you see that?
Yes.
Because I push that really hard on my tenants. I say I have to honor the law. You have to turn in your notice on or before the 1st of the month. And people stroll in here on the 10th and say, I'm moving out next month. No, you're not. You're moving. And I hold them to the fire on that. But I've never got contested that in court. Usually I work it out. So just, I didn't know if that was any kind of situation.
And that's the treatise on emotional support dogs right here.
Any other quick questions before we roll out here? Nobody have any questions?
If instead of an eviction, if I try to work out the cash for key, and it works out in the beginning, then finally he changes his mind, and I want to do an eviction, how does it work out?
You would start all over again.
Okay, yeah, if
5 day
you haven't
notice.
given them proper notice, you have to give them written notice, and do it that way. Yes.
Generally speaking, is it better to have a policy? I mean, in the beginning of your talk, you were discussing, your policies on what criminal activity is good or is acceptable or not. Is it generally better to have a policy? Let's say, okay, yes to.
No.
Okay, it's better to not have policies.
Better to say criminal activity, and it could be a violation of any city, state, federal law or ordinance. And those are what are considered to be criminal acts.
How about parking on the grass?
Parking on the grass is really probably not a criminal act unless you're getting involved with the environmental court. But,
and extending that out to things like credit score and source of income. I mean, I know you can't just discriminate source of income. Just generally speaking, I know it depends, but
that's separate. That's for whether or not they qualify to move into your house.
Right.
And you got to consider all sources that they have, whether it's from their earnings or collateral sources, to go ahead and make sure that you're not discriminating against them.
All right, last question, Mr. Moore.
On the collection side, you do file garnishments and do collections. Is there a minimum amount you need in order to do that? And does your fee come out of, say the tenant owes you $1,000, does your fee come out of that $1,000 or do you add it to the $1,000?
We handle it on the third, and you get 2/3 of any attorney fee that we're awarded, and we get 1/3 of any of the amount that you owe, that's owed to you. They owe you $1,000. You and I are partners, where I'm getting 1/3, and you're getting 2/3 of any attorney fee.
All right.
And what's the dollar amount? I mean, look, this is an economic decision on your part. You don't want to throw good money after bad. You have to have some source and idea of what they're working, and then you got to throw into the fact that if they've got 3 children, that they may file for a hardship, even though you're garnishing them. So if they're working at Taco Bell today and I garnish them, they'll be at Taco Mile next week. So it's just that.
Aye. All right, put your hands together for Robert Goldman.
Investor Weekend is not far off, with over 10 information sessions to increase your portfolio. Log on to www.investorweekend.com. Whether you are a seasoned investor or never purchased a property before, you don't want to miss the Investor Weekend. Join us for a powerful, knowledge-packed weekend with over 10 informational sessions that are bound to enlarge your real estate investments. You will hear from the best national and local real estate investors that will share practical and relevant experiences with you, the investor. There will be several networking sessions to connect with other like-minded people for potential funding, partnerships, and yes, hot deals. Go to www.investorweekend.com. Did you know we meet once a month for the Landlord Lunch meeting? The third Wednesday of every month. Go to landlordlunch.com.
Thanks for listening to the Savvy Radio Show. Glide online and listen to our other motivating episodes at savvyradioshow.com. Connect on Twitter at LandlordBook and always be buying assets.